The Federal High Court Abuja has suspended delivery of judgment in a suit filed by an advocacy group, Legal Defense and Assistance Project LEDAP, seeking the sack of Senate President Bukola Saraki and 55 other lawmakers. The judge, Justice Okunabang, suspended delivering the judgment which he said was ready in order to give the defendants fair hearing. LEDAP dragged Saraki and the 55 other lawmakers to court, seeking a declaration that they were no longer members of the National Assembly, having defected to other political parties before the expiration of their tenure. Counsel to the plaintiff and defendants speak on the adjourned judgment.
As you have heard from the court in its wisdom felt that there wouldn't be any need why they should shut the door of justice against the defendants, in spite of quote and unquote the impunity displayed. I think there was a mix-up from the part of our clients in respect of the service of the process of court. And immediately we were briefed on form, we took steps to get copies of the process and we put in our application. As the court rightly held, that has been the position of the law, that once there is an application before you, no matter how frivolous it is, you will have to decide one way or the other on the question.
I abide by the judgment, the ruling of the court, even though the conduct of the defendants in this matter does not deserve sympathetic consideration of the court. But the court finds that in the interest of fair hearing and justice, that the defendants should be given opportunity to be heard. Ordinarily, the matter was adjourned for today for judgment to be delivered. They were served with all the processes of the court as it is on the record of the court that they were served with all the processes of the court. But the defendants consider themselves too big for the law, or to respect the processes of the court. They stay back, they refuse to file processes until the matter was heard, and it's adjourned for today for judgment when they came and filed application to arrest the judgment of the court. But my Lord, who is the litis dominis, he knows more than all of us, and he has weighed the both argument of the counsel for and against, and he has made up his mind and find that there was the need for the court to give a hearing to the defendant, and so he has granted the application. I have no quarrel with that. It's a court of justice and it's a court of equity, and this motion granted does not determine the outcome of the matter on the merit. Know that the major contention or the case of the plaintiff before the court is that some of the senators and members of the House of Representatives who prostituted politically by leaving the parties to which elected or under which platform they were elected into the National Assembly, they abandoned the ship of their party halfway and joined the other political parties for their personal interest.
The matter will be heard on April 12.